Everybody, sorry to interrupt the conversations. Please continue to enjoy your meals. I just wanted to say a few brief words before introducing our keynote speaker today. As you know, I'm Adam White. I direct the center here. And I wanted just to say a few words about who we are, what we do, and what we're doing next. And apologies to those of you, Jim, who have heard this 10 times before. But the center was founded 3 years ago by Naomi Rao and Dean Henry Butler. The idea being that there were increasingly interesting debates arising in administrative law, in the courts, in Congress, and in the executive branch, sometimes reopening questions that have been settled and sometimes asking questions anew. And so the idea behind the center was to create a home across the river from Washington, D.C., which would be just a natural spot to convene and discuss, either in private workshops or in public conferences like today. And so we've hosted a number of conferences like this, ranging from topics in administrative law to discussions of the intersection of public administration with other constitutional values like free speech or due process, or sometimes we tackle a sort of industry or subject-specific issue like financial regulation or environmental regulation. But in all of this, what we really like the most about bringing people together is bringing together administrative scholars and scholars from other areas of law, and practitioners, policymakers, because we think that helps to best round out the conversation and hopefully elevate these debates that are happening around these subjects and make them useful to practitioners, scholars, and policymakers alike. So for example, a couple of things, and this is all in the program. We'll have a public conference in December on what we call new normals with a question mark, just focusing on some of the interesting issues that are arising right now in judicial review of the administration's actions. Questions about environmental policy, nationwide injunctions, just sort of an interesting mix of subjects. Last week we had a couple of interesting events across the river. First, we had a half-day conference on the Veterans Administration, or the Administration of Veterans Benefits, a discussion of how we could improve, how the process could be improved, both in terms of the agency side and judicial review. We had a judge from the Court of Appeals from the Veterans Claims to talk about the creation of class action lawsuits regarding veterans benefits. And then in the evening, we had a second event, which we called the Architecture of Bureaucracy. And that's not about agency structure. We actually had an event on architecture. We brought in a scholar of classical architecture. I know some of you were here for that, a classical architecture scholar, to discuss the transition from the classical style in Washington to the more modern styles of architecture, and just discuss what informed that transition, what can we learn from that. And so we do a lot of those. It's always a great pleasure to invite both experts and audiences alike for these conversations. And so now we're all looking forward to today's keynote speaker, the Honorable Maureen Ohlhausen. It's my pleasure to introduce her. Our keynote speaker today is the Honorable Maureen Ohlhausen. She recently completed her service as a commissioner of the Federal Trade Commission, an office to which President Obama appointed her in 2012. She also served as the Commission's acting chairman from January 2017 to April of 2018. Now, her term as commissioner capped many years of service at the FTC. In 1997, she joined the Commission's Office of General Counsel, then became an attorney advisor to Commissioner Swindell, and eventually as director of the FTC's Policy Planning Office, leading the FTC's Internet Access Task Force. Before her appointment to the FTC, she was a partner at Wilkinson, Barker, and Nauer, focusing on privacy, data protection, cybersecurity, and other FTC issues. She was a clerk to Judge David B. Santel on the U.S. Court of Appeals for the D.C. Circuit, a judge for whom I have great fondness myself. As it happens, Commissioner Ohlhausen is no stranger to George Mason University. In 1991, she graduated with distinction from our law school and later returned to teach as an adjunct professor. So it's a great honor and pleasure to welcome you back once again. Please join me in welcoming Commissioner Ohlhausen.
Well, thank you, Adam, for inviting me to speak at today's conference on permits and licenses and the administrative state. I'm definitely impressed with the high caliber of the panelists and the serious topics of this morning's sessions, such as marketable permits and energy infrastructure. But as your lunch speaker, my goal is to provide you a little light entertainment before you return to the weighty topics of bank regulation and the FDA's gatekeeper this afternoon. So instead, I'll talk about things like flower arranging and hair braiding and interior decorating. Although these activities may seem lightweight, my fundamental question is serious. Why are people who want to engage in these innocuous activities frequently required to get burdensome occupational licenses? Now, licensing, of course, has its place. It can ensure minimally acceptable health and safety requirements and may be appropriate where there are strong information asymmetries and consumers would have trouble assessing quality on their own. But consumers can and do easily evaluate the products or services of florists, hair braiders, and interior designers. In fact, it's hard to think what legitimate interest requires a state to protect the public from rogue interior designers carpet bombing living rooms with ugly throw pillows. Now, too often, government regulations like licenses and permits block or suppress competition and diminish economic opportunities. Now, this can happen because of government overreach or at the behest of incumbent market participants. Now, a few years ago, I spoke at George Mason's Global Antitrust Economic Conference about what I call the brother may I problem. And that problem occurs when a competitor controls market entry of its rivals, often through some kind of regulatory permission. And I also talked about the mother may I problem, which involves an innovator needing government permission to enter a market. And such regulations, from whatever source, are hard to dislodge and can endure for decades. Now, unfortunately, the trend has been to add rather than to eliminate or narrow these regulations. And last year, the Heritage Foundation released its Global Index of Economic Freedom. For the 9th time since 2008, America has lost ground. The United States now ranks 17th out of 180 rated economies. Business freedom and labor freedom, 2 of the 12 factors evaluated, are among those that have declined since 2011. Now, a few figures can help illuminate one aspect of this trend. In the 1950s in the United States, fewer than 5% of jobs required a license. Estimates today place that figure at between 25 and 30%. And licensing requirements reach far beyond doctors or electricians and other fields where public health and safety issues are clear. Now, jobs like auctioneer, tree trimmer, and horse massager, I'm not kidding, require licenses in many states. Other evidence suggests that such regulations are unnecessary or overbroad. Studies by the Institute for Justice and other organizations have found that different states regulate different occupations. Now, all states have licensing requirements for doctors, school bus drivers, and truck drivers. But beyond those and a handful of other professions, state licensing of occupations varies significantly. Moreover, the particular licensing requirements, such as the number of months of training required, varies greatly among states regulating the same occupation. Now, some licensing regimes require hours of training unrelated to the regulated activity, such as requiring hair braiders to undergo hundreds of hours of training for haircuts and perms, and no training for actual hair braiding. This uneven licensing of the same occupation, different requirements to obtain the same license across states, and irrelevant training obligations strongly suggest that many occupational licenses do not advance public health, safety, or other legitimate goals. Now, the proliferation of unnecessary and overbroad occupational licensing regimes not only burdens consumers in the economy, it hurts many average Americans who want to enter these occupations. A 2011 study using standard economic models estimated that restrictions from occupational licensing resulted in up to and 2.85 million fewer jobs with an annual cost to consumers of $203 billion. Now, I am particularly concerned that occupational licensing disproportionately affects those seeking to move up the lower and middle rungs of the economic ladder, as well as military families and veterans. Occupational licensing regulations can prevent individuals from using their vocational skills and entering new professions, as well as from starting small businesses or creating entirely new business models. And furthermore, because military families often must move frequently, occupational licensing is a significant barrier for a trailing spouse seeking to practice his or her profession in a new state that may have additional or different licensing requirements. And while I was the acting chairman in December of 2017, I held a fireside chat with individuals affected by excessive occupational licensing, several of whom were military spouses. And they spoke movingly about the burdens placed on them and their families by constantly having to be relicensed to work as a teacher or paramedic as they move from state to state every few years. And more worryingly, they identified this as a hurdle to retention for service members, which impacts our military readiness. And now occupational licensing can also be a barrier for veterans seeking to return to civilian employment. Now, if so many occupational licensing requirements are not necessary to protect consumers, why do they exist? Now, in my experience, such regulation often reflects regulatory capture, replacement, or overreach. Indeed, I have found that it is frequently self-interested, active market incumbents promulgating rules, imposing occupational licensing requirements to prevent competition, rather than direct state legislation. Now, public choice theory recognizes that industry capture of regulators for private economic gain is most likely when incumbent providers can obtain a concentrated benefit while dispersing the competitive harm among many consumers. And such unproductive rent-seeking behavior limits competition in the market, and it often protects higher pricing by incumbents than would exist in a competitive market. So what can we do about this? I've talked about the problem. What can we do to try to address it? For the past 15 years, I've played a central role in the fight against excessive government licensing and the battle to expand economic liberty. And I'd like to share some of that history, some successes, and ongoing efforts. Now, Adam mentioned I recently finished up my term at the FTC, where I was a commissioner and the acting chairman, and I ran the FTC's competition advocacy program when I was head of the Office of Policy Planning from 2004 to 2008. And I'm proud to report that the FTC has a long history of fighting to unshackle markets from competition-limiting state regulatory burdens. And the Commission has devoted significant resources over the past 40 years opposing state laws and regulations, including many in the occupational licensing area that unnecessarily restrict competition. And the Commission has used two very different tools in opposing such regulations. And the first one is law enforcement. It brings cases to address anti-competitive practices, including practices by state-appointed boards that harm competition. Now, as you all know, in the U.S., we operate in a federal system with sovereign states, which limits the reach of federal antitrust law pursuant to something called the State Action Doctrine. And that doctrine immunizes from antitrust liability sovereign actions of the states, even those with anti-competitive effects. And beginning in 2001, the FTC sought to clarify and reaffirm the original purposes of the State Action Doctrine to better protect consumers and competition, and I was privileged to be part of this effort. And the FTC issued a report that recommended clarifying that the law ensures immunity only if the state itself and not a private actor restricts competition. It also sought to require states to clearly articulate any plan to displace competition and to actively supervise private parties carrying out that plan. And the Commission brought a series of cases starting in 2003, which culminated in two Supreme Court victories. In these cases, called Phoebe Putney and North Carolina Dental, the court adopted the FTC's recommended approach and clarified that state action immunity does not extend to actions by boards made up of active market participants, and that to avoid antitrust liability, they must act pursuant to a clearly articulated state policy to displace competition and be actively supervised by the state. And I hope that the Supreme Court's decisions in Phoebe Putney and North Carolina Dental will provide wider benefits to competition and consumer welfare. Given its holdings, many state agencies throughout the country will need to examine and revise their practices. And studies suggest that in some states, more than 90% of licensing boards are controlled by active market participants. Now, having active market participants on boards can offer valuable and potentially unique expertise in making important regulatory decisions. But the Supreme Court was clear. While under our federal system, states may meddle with the free market, when they do so, they must be politically accountable for whatever market distortions they impose on consumers. Now, I also think these cases have significant implications for occupational licensing regimes more generally. And I hope they will prompt the reevaluation of the excessive state licensing regimes that have developed over the years. And I'm pleased to report that several state governors are doing just that. Last year, Pete Ricketts, the governor of Nebraska, launched an occupational licensing reform initiative. And governors in Arizona, Missouri, and Wisconsin also are each seeking to remove occupational licensing restrictions that limit job opportunities and hamstring those seeking to start small businesses. And fortunately, such reform should garner support from across the political spectrum, appealing to those who wish to expand economic opportunity for low and middle income workers and keep prices more affordable for consumers. Now, one of my signature initiatives as the FTC acting chair was to create an economic liberty task force to advance economic liberty issues with a particular focus on occupational licensing. And I actually announced that here at George Mason in February of 2017. And the task force is a way to bolster the agency's efforts to address occupational licensing restrictions and other barriers to economic opportunity, and a vehicle for working with interested parties, including the states, to prevent and, where possible, reverse such regulations. Now, often state and local legislators are only hearing one side of the story, the one from the party who will receive the concentrated benefit. And they often don't hear about the substantial, albeit diffuse, costs such regulation will impose on the very constituents they wish to protect. Now, I think it's important that state and local legislators hear both sides of the story, and the task force is a way to amplify the FTC's efforts in this regard. Now, I've already mentioned the FTC has two primary tools, and I talked about enforcement, and now I'll talk about advocacy. Now, since the 1970s, the Commission has issued hundreds of comments and amicus briefs to states, state boards, and self-regulatory entities addressing professional licensure across a wide range of industries. And state legislators and boards often ask the FTC for input on changes to existing occupational licensing. But I also want to be clear that occupational licensing is not a binary choice. It's not whether to have a license or not have a license. It's important also to have the right level of licensing for the task at hand. So, for example, in its submissions, the FTC has identified the need to adjust occupational licensing to get the benefits of things like expanded use of telehealth for the provision of certain services, maintaining the same standard of care, but expanding access to services, often to underserved and remotely located populations. And the Commission has also advocated for expanded roles for advanced practice registered nurses and for physician assistants to increase access, choice, and even quality to enhance competition while still meeting public health and safety goals. So, as Adam mentioned, I recently finished my tenure at the FTC. And on September 25th, which was my last day at the Commission, the agency released one of the Economic Liberty Task Force's projects, a report entitled Options to Enhance Occupational License Portability. And this built on a roundtable that discussed reforms that promote reciprocity among states and credit work experience in place of additional educational requirements to help remove barriers to entry and competition, particularly for military families and veterans. And the report looks at things like interstate compacts and model laws that states can use to improve the portability of occupational licenses. And it also examines procedures that might be adopted to facilitate multi-state practice by those who already hold a valid license in one state. And it considers specific initiatives to reduce the burden of state relicensing on military spouses. Now, just to conclude, my work on competition advocacy and economic liberty, including the battle against excessive licensing, has been some of the most rewarding of my long career. And I'm also pleased that I have many allies in the fight to expand economic opportunity, including many state leaders, some of whom I've already mentioned, as well as federal officials. So, for example, I was pleased to see Alex Acosta, Secretary of Labor, take up the cause in an op-ed earlier this year. Now, although my time at the FTC is done, I'm confident the new commission, under the leadership of Chairman Simons, will continue the fight to bring more competition into markets, help those seeking to enter and compete, and enhance consumer choice and access. And I encourage anyone who cares about these issues to join as well. So thank you, and I'm happy to take questions. Okay. Okay.
I'm curious, the FTC obviously wears multiple hats, and in addition to thinking about state occupational licenses, the FTC itself doesn't grant licenses, but it has an approval role in antitrust. And I'm just curious how your work in granting and denying, approvals for antitrust mergers and other, aspects of the FTC work, how did that inform the way you look at this power of state governments to grant and withhold approvals?
Yeah, that's an excellent question. And actually, I'll talk about the Phoebe Putney case, which was the first Supreme Court case in our two victories on the state action doctrine. And it involved the issue of we had a merger to monopoly in the state of Georgia, actually, between two hospitals. And one hospital system was like a municipal system. And so they said, this is immune under the state action doctrine. And the 11th Circuit agreed with them. And we went all the way up to the Supreme Court, and we won that. We won that case unanimously. But when we tried then to impose a remedy on the merger, we weren't able to undo it because of the state certificate of need licensing regime. So looking at that issue, so this was where these issues came, right into conflict with our merger review process, and why getting state action right is so important to competition. But it was very frustrating because we won unanimously in the Supreme Court this case, and we weren't able to actually undo the damage. So I thought, well, try to make some lemonade out of these lemons. Let's do a study of quality. What was the impact of this merger? And what FTC economists found was it actually led to, well, I would say that there was it's hard to say it led to, but basically there was a correlation between having worse health outcomes if you were an elderly Medicare patient after the merger than before. And that controlled for this population and other hospitals too. So what it really brought home was the fact that competition gives the best outcome for consumers, right? Licensing is important. You want minimum safety standards, but screening out competition has a bad impact, not just on prices, but on health outcomes.
You mentioned the magic words, certificate of need, or CON.
Yes.
I know of a couple of situations. One was the moving company that couldn't move in the next state because the group controlling the certificates of need were the moving companies of that other state. There was one slightly off the mark where the monks of a certain monastery had a business making wooden coffins, and the state board of funeral directors decided that they sued because they were the only ones able to sell caskets. And the only cure would be for one of the monks to become an undertaker, doing preparation of bodies and everything else to sell a simple wooden coffin. You're familiar with those, I'm assuming, but can you talk further on the certificate of need problem of the states?
Yes, so I am very familiar with them. Actually, the FTC filed an amicus brief in that case, and the monks were successful in the Fifth Circuit for getting that statute struck down. But certificate of need is really the classic example of the brother may I problem, right? Where you need your competitor's permission to enter the marketplace. And the FTC, now these were imposed supposedly as a cost savings kind of regulation when it used to be like a cost plus kind of reimbursement. But we've moved far away from that. But certificate of need laws have stayed in certain states. And they are problematic, right? You have to basically get your competitor's permission, and your competitors are happy to go in and say, no, we don't need a new x-ray machine, or we don't need a new clinic, or we don't need a new, hospital. We've got it covered. It's only going to drive up costs if our, competitor comes in and opens. And you will see in Fairfax County, there hasn't been a lot of entry in new hospital. We've got Inova, but now we finally, I think, have a new entrant. But it's certificate of need is one of those things that I think is states should take a very hard look at. And it's often now, it was originally put in place as a cost containment measure. But now the argument is often put forward, well, no, this is about, we don't want competition because it's going to reduce care for indigent populations, that we're using this extra money, this extra competitive profit that we can get, and we're transferring it over to help indigent patients. And I don't really think that argument holds up. Or maybe it should just be done directly rather than through extra competitive pricing. Tom?
Thanks for your talk, Commissioner, if I could. A generation ago, the Federal Trade Commission was very active in bringing suits against states for cartelistic restrictions, limiting advertising for certain professions. And I was just struck by your very nice presentation of the anti-competitive nature of professional licensing, which is, of course, a cartelistic restriction. Is litigation part of this plan, other than suing the states for anti-competitive conduct?
Yes. So the FTC has continued to bring enforcement actions, including one against in Louisiana, the state board of who oversees property assessments. And it's actually an opinion that I wrote when I was on the commission, is now on appeal before the Fifth Circuit. It's basically taking the Supreme Court decision in North Carolina Dental and applying it. Like, what is a board made up of active market participants? What's active supervision of that board? What actions by the state, the governor or the legislature, is sufficient to give state action immunity? So I tried to continue the battle, and I believe the FTC will continue to do
When
so.
you mentioned the interior decorators being professionally licensed in the protection of the public safety therein, I had to search. I know astrologers are not licensed in the state of California, but I know there was legislation introduced to license astrologers, which always to me, I was hoping that would pass. That you don't want substandard astrologers.
That's right. That's right.
Absolutely.
Well, the thing about astrology is the board doesn't actually have to administer the test. They can just predict who will pass. So we have two. So maybe Dan, and then the lady in the back.
So thank you for that. I think that is really one of the burning issues in the United States. And you alluded to this, but clearly there's a bipartisan agreement, obviously, at the FTC, because you talked about the FTC being consistent across 40 years. That would be both Democratic and Republican administrations. This seems to be such an issue on which right and left should make common cause. I mean, crony capitalism, entrenched privilege, harms the least among us. We know that there's IJ out there and others, but are there any groups on the left that have taken this up? And if not, why not?
Well, there are groups who have taken this up, including I've spoken before state legislators, minority groups, because they see the impact in their communities about health care not being provided, about these very strict licensing requirements keeping access to health care suppressed. So they're very interested in it. And the Obama administration actually put out an excellent report on this issue. So there really is a lot of bipartisan support. The hard part is, at the state level, how do you address this? But for telemedicine, this is enormously important. And particularly not the license, not license issue, but allowing someone like a nurse practitioner to practice to the top of his or her license, right? To be there with the patient, and then you've got the doctor, remotely diagnosing. But there was a case in Texas when a telemedicine service called Teladoc tried to enter. And the medical board said, you can't use telemedicine to diagnose a patient unless you've seen them in person first. But their rules did not prohibit doing it over the telephone. So over the telephone, as a doctor, you could diagnose someone who you'd never seen before. But if you had the full video connection, right? No, that wasn't allowed. So we brought an investigation. There was a private suit, and eventually the governor struck that down. But this is a very important piece. Question in the back.
Hi, my name's Elaine Middleman. I'm an attorney. Since we're sitting in law school, I have to ask you, do these issues apply to licensing for attorneys?
Yes, they do. Yes, they do. And so how I really got into this issue was the issue of whether you needed to have an attorney do a real estate closing. And there's only a handful of states, mainly on the East Coast, where you have to have an attorney do a real estate closing. And Virginia is a state where we can have what's called lay closings, which is people who aren't attorneys or attorney closings. But there are some states like Georgia, South Carolina, a few others where you have to be an attorney to do it. And it was an interesting kind of thing. And so as the FTC, we did this jointly with the Department of Justice, actually. We filed a lot of advocacy about this issue because it raises costs, and studies show it doesn't increase quality. I mean, a lot of real estate closings are very cut and dried, and people who do more of them, are better at it. And so lay people actually, who practice in this area, they aren't making a lot of, mistakes that attorneys would, that attorneys wouldn't make. But the interesting thing about that was one of the only times I was ever heckled as the speaker was when I was invited to the North Carolina Real Estate Attorneys Conference. And they did not like the federal government's position on these issues. So we have, and it's really an important access issue. And some of the DC Bar has been very forward-looking on this because they really see it as an access issue. I mean, it's this idea, and we see this across professions, where there's one argument like, well, you want the best service and you want, the highest quality. And it's like, yeah, theoretically, yes, but at what cost? And you're cutting, it's kind of like saying if everyone has to drive a Cadillac, there's going to be a lot of people walking, right? And so I think that's the way we need to look at these things.
Been a fascinating conversation about a topic I've read about but don't really know other than that much about. How have most states that have had this problem of stakeholder, but then air quotes, controlled boards remedied the problem after the Supreme Court ruling? Have they just sort of put the agency director in charge of affirming or denying a board decision, or and do you recommend any kind of best design for a state government that might still need to clean up its house?
So they're still working through it. One of the things that we did at the FTC after the decision came out is try to issue guidance to states about what would be active supervision, what's a board of interested market participants, things like that. But some states have tried to go the other way and just sort of pass a blanket like, oh, it's all covered. We have a law saying it's all, it's all state action, and so there's been different things. And it's an interesting kind of dynamic because within the state attorneys general offices, you have lawyers whose job it is to defend the boards, and then you have the antitrust people, and the antitrust people are very sympathetic that this could be a path for anti-competitive behavior, but the state attorney general's office is often there to defend state entities. So there's, we continue to work on these issues. So it's kind of interesting.
Any kind of best practice, though. I mean, if you were going to, let's imagine that some of these boards are necessary to license occupations. What would be a good design from the ground up if you were going to redo it?
Well, I think one thing that would be useful is to have someone in the state government who's not an active market participant oversee the decisions of the state licensing board. So, for example, we talk about the North Carolina dental case. There was a case before that called South Carolina Dental. And the state legislator there had actually rescinded the requirement that a dentist be present when dental hygienists went into schools and did screenings and cleanings for poor school children. And the state board of dentistry then went in and had an emergency regulation that put this back into effect. So you could imagine if you had someone at the state level reviewing that and saying, the state legislature just rescinded this, you can't go and put this into place now. But that was a hard-fought battle. The FTC brought an enforcement action that was eventually settled on that issue. It was a hard case to sell to the litigating staff at the time. I actually had to do it, and I was like, "This is a great state action case," and they were like, "No." Like they had all these reasons why we weren't going to prevail, but I was like, "We will," and then we did, and it just kind of launched this whole great spate of cases, including eventually the North Carolina dental, which was about tooth whitening.
Thank you. Thanks for your service.
Thank you. It was my pleasure. Great. Well, thank you so much, everyone. Thank you.
Commissioner, I hope we gave you a warmer welcome than the real estate lawyers. So, everybody, we'll take a 10-minute break. We'll reconvene at 1:30 for the discussion of fintech and bank chartering.